What's up? It's your boy Kevin to turn on this motherfucking YouTube shit. Wow, what the fuck?
What's up? It's your boy Kevin to on YouTube shit. Hey man, say man, we are lit, man. Turn. Take motherfucker day. Show hitting outside. Big Quicc in the gang. Show hitting outside shit, man. Free Palestine, free Congo. Russia, do your thing, and Texas, stand the fuck up. Each day is a new day to be a better version of yourself. Never let somebody bring you down. Always fight back. Never let somebody tell you who you are, but also never put yourself in a position alone. Let's stay humble. Let's get a revolution on the movement. Keep Yahweh first. Coming to you as a black Hebrew Israelite. As a real Jew, we out here. Alright. Boom. Today, to motherfucking day. So hitting outside. Big Quicc in the gang. So hitting outside shit, man. Free Palestine, free. I'm tripping at this bitch. Alright, man. So, yeah. We're tripping. We got motherfucking. Your boy hiding, bitch. I ain't gonna cap. Give me a second, bro. Your boy tripping like a motherfucker, bro. Hiding a motherfucker, man. We got YNW Melly, bro. Boy, hiding a bit. YNW Melly, man. Now, this is what we got going on, bro. With this YNW Melly shit, man. You know, he trying to get free from this motherfucking shit, man. He trying to get free from the jail system. You know what I'm saying? And a lot that happened in the past trial is kind of fucking up his shit because the witness tampering and basically that he can win this case, bruh. But they trying to hit this nigga with this witness tampering, bruh. Like, it's past the bodies at this point because the court know he didn't do it. This court system know that he didn't do it. So it's almost to a point like they got a vendetta against this nigga. They trying to do anything. They say, man, if we can't get you on his bodies, bitch, we gonna get you with the legal system. So I don't know, bro. Hopefully we can keep on fighting because, like I said, the lawyer and YNW Melly both got some shit going on, bruh. It's like, damn, man. But it's still a chance. So we're about to get into this damn court and let's get into it. Alright, gang, y'all know what the fuck going on. Quicc, we out here trying to help YNW Melly get a bail bond. He's trying to get released in this bitch. You know what I'm saying? He's looking kind of crazy because Quicc, they out to get YNW Melly and his lawyer. So it's like they trying to add more cases on YNW Melly while he got these cases. Only American KKK, gang.
As the court has repeatedly pointed out, Mr. Demons is charged with the death penalty. Many countries in the world will not extradite back to the United States.
And he got a mid-trial.
So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
YNW Melly's high-profile retrial is just 4 months away, but the defense is hoping to get him out of jail on bond before that happens.
6 years ago. It's been 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of
man, this bitch best have some good shit, bruh.
Needs, basically.
I'm Elizabeth Milner with Law and Crime. Jamel Dimmons, aka YNW Melly, has been in a Florida jail since his arrest in 2019, so more than 6 years ago. And in that 6 years, Melly went on trial, which ended in a mistrial after a hung jury. And despite facing 2 charges of capital murder, the defense is still pushing for bond and offering a number of compromises if the judge allows it.
There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I agree with you. That's why we're here today.
It was a packed courtroom this week, mainly of Melly's family, when the Florida rapper appeared before a Broward County judge. And before the judge heard arguments about why Melly should or shouldn't be allowed the chance for bond, the judge heard from the lawyer of the victims' families first.
I think the victims and family members just wanted us to at least place an objection on the record. Let their feelings be known. Of course, under Marxist law, they have that right. And so we filed that objection just so Your Honor knows what their position is, what our position is here, that we would be, the family members would be.
So they're trying to keep YNW Melly.
The defense tried to call a witness to the stand to testify at Tuesday's hearing. It was Dr. Heather Holmes, a forensic psychologist, but the state wasn't about to let that happen.
We're going to be objecting to Dr. Holmes' testimony just because she was noticed in the state less than 36 hours ago. She's going to be testifying as an expert. We don't know what documents she relied upon. We don't know what materials she was given to review. We provided no reports in order to go to the substance of her testimony. When was she listed as a witness?
She was listed, I believe, Friday evening after we
This
invited her.
bitch put some magical shit on her ass.
There was no report.
Cause ain't shit funny. They trying to get both y'all niggas off the chain.
Stop.
You listed her Friday after.
I believe so.
Okay.
Your Honor, I can tell you the court filing came in and it's on Odyssey from it was about Sunday evening.
So you don't want her testimony to be considered today in the hearing?
We're fine bifurcating once we, have enough time to know what she's going to testify to, know what she relied upon, have time to look into that. But today, with, as Mr. Griffith said, less than 36 hours, we're not at all prepared to have an expert.
Is she in fact testifying as an expert?
She is testifying as to basically the second portion of my motion
Why they need
going
it?
to
What the fuck is going on with you?
the appropriateness of the bond.
You
So
need your ass
I
to
am
speak to this
tendering her up
motherfucker.
there. She did sit with them. She has information to provide to the court.
She interviewed your client?
Yes,
She's going to testify about that?
Yes, Judge.
And just so your Honor's clear, the e-filing from the court, the clerk's portal came in at 10:31 p.m. on 5/4, which was Sunday evening.
Okay, so the state's objection is sustained. She's not going to testify today.
So a loss for the defense there, but the lawyers still need to do what they do and argue their reasoning.
The circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release. If the defendant can prove that his conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight. Is he a risk of flight? So going through that. What we would be proposing for Mr. Dimmons would be a minimal monetary bond with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged to one. It was two.
So why
when
they
I
trying so
asked
hard to
for
keep me in? Cause they play
Mr. Dimmons would have a 24-hour security guard on his person. There would be then 2 other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Dimmons. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. So you basically have your own deputy, paid deputy, with him. Mr. Dimmons is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time.
Yeah, he's going to jail for 6
We can
years.
assure his presence at trial. He's been
Fire
here
like a
every
motherfucker. He probably
hearing.
didn't have one when he got in.
He will be here
Let's
every
be honest.
hearing. He would have a monitor on him.
Maybe
The
have
court
other
would
niggas
know
drive
where
for
he
him.
would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal with the security on, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm. Given the singular event that Mr. Demmons is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event.
Let's be honest. Nigga's rich as hell.
If there was a concern for public safety, I think
he might be trying to
I
take
would
them
meet that
motherfuckers.
concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm.
So GPS tracking, a 24/7 security guard, money to post bond, that pretty much sums up what the defense is offering. But Melly is also charged with witness tampering, something the judge will likely take into consideration. But the defense had an answer for that too.
That case was very convenient.
And that's the shit that's going to kind of fuck them up. Because even if we beat this case,
and it does affect
the other case, the witness tampering can be on some fuck shit.
You recently heard our motions.
Damn.
I was trying to lift the state to argue that C4 motion. The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demmons' trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That is the only basis of what the state will argue, is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person.
They do it to every black person that's in jail. That's famous. How y'all notice that? Every nigga that's in jail, they always trying to say it's witness tampering. Every case, nigga.
Based off the true facts, there's not been any tampering.
Like, that's wild.
When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that.
Ready.
And the whole basis for it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demmons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not, did anything. He did the right thing, Judge, and he turned himself in, I believe, February 13, 2019, 6 years ago. It's been 6 years of his birthdays in that jail. The last 3 years that he's spent in that jail, he has been deprived of basic human needs, basically. He's currently housed in a situation that's 23-1.
Counsel, I hate to interrupt you, but there's no evidence.
Okay.
The lawyers
Damn.
present some evidence. I read that in your pleadings, but there's nothing in front of me about what his current conditions are in the jail, so I can't.
Okay,
He not going for nothing.
So,
He like, y'all not finna say some shit about this, but
the conditions in the jail
Fuck,
are
Melly.
good. He's been there 6 years, Judge. The Constitution says everybody gets the presumption of innocence. 6 years. We're going now past 6
this
years.
motherfucker lawyer
He has
asshole.
substantial ties to the community, to his mom, to grandma,
Yeah, he don't give no
his
fuck. He's
sister,
an
his
asshole.
brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case law. That prove evident agree, that's one thing. You go to the second. Are there special conditions that we can put in place to protect those three things? To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. We were precluded as putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demmons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the court, of the judiciary. And I believe we admit it, the state has not presented to us any reasons or any special conditions that would say that he should not be eligible for a bond. And I will also just point out that the whole purpose of bond is not to punish the defendant, it's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected.
And what was the state's response? Well,
the defendant is charged with homicide. He's killed 2 people, so he's clearly proven himself.
Allegedly.
He is.
Look at this.
Please, one at a time.
Look at this.
He's already established
That's
that
a whole
he
ass
presents a
shit.
danger to the community. But not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry
Look
is
at
back
that
in
shit.
custody.
He's
because he
literally
did have a bond, and that
bitch.
bond was revoked.
And he looking at
Had Mr.
him.
Devon's been on
He ain't
bond,
looking at
his
her.
bonds obviously would have been
Y'all
revoked,
see
and
that
he'd be
shit?
back in custody
Like,
as
I'm
well.
not tripping. This
Because there
judge
was
is like
probable
crazy.
cause and a new crime was committed. But to say that there's, and I'm not going to litigate the C4 motion, but to say there's no
He
evidence
looking at it
is
straight
also
in.
not
He
an
looking
accurate
him straight in
statement.
the
There
eye.
are videos,
He wasn't paying
jail
attention to nothing
halls,
she was saying.
kites all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that
He
he
looking
can
him
go that
straight in
he's
the
not
face.
known,
When she
that's
was
not the
talking, this
concern.
nigga wasn't
The
looking
concern
at
is
nothing
he
she
goes
was
somewhere
saying.
where
He
he
damn
cannot
cracked his
return.
man.
As the court has repeatedly pointed out, Mr. Demmons is charged with the death penalty. Many countries in the world will not extradite back to the United States if they are facing the death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
May I respond, Judge?
Okay, last word. Go ahead.
So, as to your comment,
Let's see what. Look at this.
in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proffer. I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. Give me the address. We would have the security detail, all that he would give it to you in camera. As far as the second amount, his record label would be, if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the financials would be covered because it would be coming from his record label. I wish he had a little bit more spark in her voice. He is actually duly employed. He has a recording contract. He would be able to work and have a source of income. And we'd have conditions in place to ensure. As far as what the state's arguing that they're afraid he would flee, I again think we alleviate any concerns when I put security on him.
She got hit with a lawsuit 3. She get not lawsuit, but you know what I'm saying? They trying to get her ass with this
him 24 hours a day, and another individual monitoring the property. They would be reporting back to not only the defense team, but to the state attorney and to the court if there is any issue. Again, the ankle monitor.
Damn, nigga.
It's being monitored.
Really happening?
I've had other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Demmons, while being on house arrest and a GPS tracking monitor, had abscond to another country is basically ludicrous, Judge. It's an impossibility. It cannot happen. We have met the factors coming under those 3 different combined statutes: protecting the community, protecting the integrity of the judiciary, and basically making sure that he shows up to court. I believe we have proffered enough for the court to basically be able to rely on the fact that he meets those factors. The state has not raised any additional factors that would say, all right, he's not eligible for the bond.
Despite a packed courtroom, likely hoping the judge would make his decision right then and there, Judge Fine instead is going to hand down his ruling in the next few days. But the bond issue wasn't the only matter brought up in court on Tuesday. A lot of the other arguments had to deal with what will be admitted into evidence during Melly's retrial, because remember, there was a different judge on Melly's first trial.
As to the first motion to suppress the T-Mobile records, that was denied. The cell phone location records where the defendant was that day with his phone moving around, that remains in evidence. As the second warrant, the Twitter account that was granted in part, the past events from leading up to the homicide were suppressed, which means the admission that was made on Twitter is kept in, but the aggravators relating to the defender's activity and belonging with gangs and his gang membership, that would be out. As to count 3, number 3, the iCloud, that was granted in part. I think we noted that there was nothing of import there, so we weren't using anything from that, or we didn't recover anything from that. To the Snapchat, that was granted in part. Again, the day of the homicide, so the location information, the communication records from that day remain in. The messages from the defendant's ex-girlfriend, Mariah Hamilton, those occurred afterwards. Those would be out, but those were not introduced in the first trial. We do intend to use them, but those were not in the first trial.
Justin, you say out? I don't understand. I just want to make sure.
Out. Mariah Hamilton's text.
When you say out?
Out, as in they're not in evidence. They were suppressed.
Oh,
it's subject to suppression. It's subject to suppression.
I want to make sure out and it was suppressed. Thanks.
As to number 5, the Google records, that was denied. As to 6, the Facebook account, that was granted in part. Physical location, FaceTime info, connection information, photos from the homicide up to when the warrant was suppressed on January, or when the warrant was applied for in January, that remains in. So what the state lost there potentially are photographs related to gang-related activity, the defendant's membership in gangs, as well as some comments and communications about the defendant promoting the promotional video, which is also subject to the appeal, because we argued adoption by admission because he was promoting that video. But all those communications were after January 8th, or at least some of them were, I think. The Instagram Instagram, which was number 7, it's effectively the same thing as the Facebook, the gang activity. Number 8, the T-Mobile records, the real-time location information, that was denied. Number 9, the T-Mobile records for historic location information as to the defendant, that was denied.
Yeah, fuck 12.
Number 10 is moot because it was the wrong phone. The detective got a new warrant. Number 11, the defendant's iPhone, it was granted in part from the date of the homicide up to February 13th. So we obviously kept anything that was backed up to that phone, including the pin drop information, some notes, some text messages in reference to gang activity. But what we also was suppressed were some of the notes and text messages from the past relating to gang activity. Where'd it go? Number 12, the Google accounts. There were 2 accounts. We lost everything prior to the homicide was suppressed. That includes gang-related information as well as the gang Bible that was recovered from his account. And then number 13, which is what Ms. Collins was checking, the YNW booking. I actually didn't know offhand what was actually suppressed from that, but I believe it's more gang-related stuff.
But none
So
of this sound like
what
it
was
should be able to
suppressed
hold him
was
back in
a lot
jail.
of stuff the state would be using for aggravators.
Southside location information
Remains in.
from October the 26th, 2018.
Which looks like Muppets.
Correct. And that's my summary. If they disagree, because I was trying to prepare this for today's hearing, I didn't have the time to go through every piece of evidence.
I think it was the same of what I said. But just to go a step further so the court understands,
Right.
I agree with
listening to that
what the
motherfucker, but she
state
said the
had
same.
proffered as far as what's suppressed. Going to what specific witnesses testified to what we agreed was suppressed. You'd be looking at the majority of the testimony from Danny Bullock would be out. He testified to a lot of the photographs of Mr. Demons' phones that predated, as Mr. Griffiths said, the booking, the YNW booking, Gmail had a gang Bible sent, some gang talk sent to that Gmail. All of that is out because it predates the murders. That is most of what Danny Bullock testified to. The second witness who would have testified to certain messages, maybe with Mariah Hamilton, Detective Mark Moretti testified to a substantial amount of text messages that would now be suppressed. So I believe we said close to half a day where he just read text messages off of the screen. Most of that would be out.
How about the text messages from October 26th? Were there any?
Those would remain in. As far as his phone is concerned, it was granted in part from the date of the homicide to February 13th remains in.
So
what does all the legal back and forth really mean?
incriminating?
Essentially, the state still argues they have a strong enough case, even with some of the suppressed evidence out.
We believe that proof evidence still remains strongly present because, as the court was noting, all the information from the day of the homicide remains. So the vast majority of the evidence that was introduced in the previous trial remains available to the state. What the state effectively lost, as I summarized, were a lot of the enhancers that were used, such as the gang activity, some of the information that goes to motive. But for the day of the homicide, the ballistics that shows that the shots were fired from inside the vehicle, the fact that Mr. Henry lied about the events, which was corroborated by the locations that were determined where the shooting actually took place, with the shell casings that were recovered, the fact that the defendant's phone was traveling with the 2 deceased in this case along with them and then separated prior to Mr. Henry going to the hospital, the admission on Twitter that the defendant made where he said, "I did that," all that stuff that relates to the homicide, to the direct evidence for the guilt portion remains in evidence. So effectively, nothing has really effectively changed other than some of the arguments that the state can present to the jury in terms of both aggravators and motive.
So
This nigga on all teams alike.
This argument,
With this motherfucker cracking.
based on their written pleadings, I suspect they're going
Pussy.
to tell me that since the jury didn't find him guilty of these, that's beyond a reasonable doubt. We weren't able to do that to the jury. So you're now asking me to find a higher standard that is proof evidence presumption breaks. If you have any response to that.
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready to cut that case.
I have no idea what this.
That it was a hung jury, and we don't know what their decision was.
It was, Judge, I have to check the characterization that we don't know. It was was mistried because they couldn't unanimously decide.
And that's a
Which
fact.
is the standard by which somebody is found guilty or innocent. So,
I'm not considering votes. I got it.
So he's not guilty.
No.
As I always say, we'll see what comes out of this and what happens next. Melly's retrial is expected to begin this fall. YNW Melly's next court hearing is slated for late June. As for his retrial, that's set to start on September 10th. Reporting for Law and Crime, I'm Elizabeth Milner.
Shout out to District Trending.
In case you missed it, the news wrote, YNW Melly's lawyers submitted their last paperwork for Melly to be released on a bond until trial in September. This time they have full confidence Melly will be released from jail, as Melly's mother would give an update on his release.
We're just still praying. I know I said I would I'll keep everybody updated with what's happening. I know right now we're waiting. So basically the judge is going to do, I guess, a written order. So we're just waiting, and that order can come any minute, or it can come tomorrow. I don't know. So we're just waiting. We're just waiting. So everybody just keep praying, keep having faith. Tessa, stop. I've been crying too. It's been a long time coming, you know.
As Melly's lawyers handed in his new bond release package, you tell me if it's worth his release. As lawyers wrote, Melly's legal team proposed posting an unspecified bond that would be paid by his record label 300 Entertainment. If granted a bond, they assured the judge that Melly would be on house arrest, wear an ankle monitor, as well as hire round-the-clock security to keep tabs on him. It was so good that a rapper wrote, "That boy Melly's coming home. I feel it." However, it's the physical evidence they added to the bond release package that will get him free, such like the interview that Melly's mother did explaining that he isn't being treated like a human inside a jail, which is illegal.
When you saw Melly's statement, just saying how he's been hurt, how he's scared for his life, as a mother, how did that make you feel?
It's heartbreaking. It made me feel completely helpless. Broward Sheriff's Office definitely needs to be investigated.
Facts.
I mean,
all these pussy ass cop facilities.
We've tried to go
They
to
some
court about this
pussy,
situation.
man.
The judge really doesn't
Whole ass
have any
motherfuckers.
jurisdiction
Bunch
when
of
it comes
crackers
to the
running
jail,
around trying to
because we
hoe
actually
niggas.
had a hearing about
Use
the
niggas.
mistreatment of him, and the jail they make their own rules.
They do.
And I don't think that's
If you
fair,
don't follow their
because
rules, they
I
can
know
fuck
that
you up
they
in that
need
bitch.
to answer to someone too.
They would then bring up evidence from the original trial that this new judge wasn't there for, showing proof that when the feds say that Melly committed the crime inside of the Jeep, it is false, as there's GPS evidence proving that YNW Melly was seen sprinting down the street and hiding into a bush as his cell phone was being tracked by AT&T in his jeans pocket.
That would be the part where she's saying that someone just shut the car up and was trying to shoot them. So I asked him if he was okay, where he was, and he's like, there's a car coming behind him, like hiding. He was like, there's some, there's some, I think they're still out here or something. So I'm like, are you okay? He's like, I'm okay. I said, well, where are Zach and Juby? And he said, I don't know if they're in the car. I think they're...
Then, to back up the claims of it being an actual drive-by, in the original trial it was confirmed there was never a firearm even found, making the claim of it being a drive-by very likely, as the guilty party drove off with the firearm used.
So the first thing is I didn't have a firearm, so I can't know which firearm I'm going to use in order to replicate any of my tests. So I can't make tests for the dissertation because I don't know what firearms used.
Okay.
With the release package looking so good, the prosecutors even got afraid that it would be accepted. This is when they did something concerning, as the news wrote, a no communication order has been filed in the YNW Melly trial. This order makes Melly and Bortland completely separate. No talking, no lawyers, just silence, as the prosecutors are forcing Bortland to snitch by trying Melly and Bortland together in the next trial, meaning they'll be sitting next to each other while evidence is shown of them doing the crime.
Issue here, and you can try them together. It is to the benefit of the state to try them together. It's just more efficient. You don't have to do things again and again. Do it all at once, and also you get a better chance of having them incriminate each other during the trial. it benefits the defense to sever it. That way they can point the finger at each other and get away with it. So this is what's going on. But I don't think it should be automatically severed because the state is seeking penalty for Melly, because it's only the penalty phase of the trial that would be different, not the guilt phase. The guilt phase is the same. They're both capital crimes. You're seeking the penalty on one, not the other, but that goes into the second part of the trial, the penalty phase, only if Melly is found guilty.
This was the mistake that the prosecutors made on the first trial, not having them both sitting beside each other. As if Borland knows that he didn't commit this crime, he won't physically be able to sit there and take life in prison to the chin, making it very likely he'll then point the finger against Melly, as the prosecutors, they're doing it for one specific reason. You may remember in the original trial, YW Melly's lawyers were trying to pin the crime against Borland.
Those were his lies. Corwell Henry shows up at Memorial Hospital, Miramar, and you don't see him sitting there, but where you will see him sitting is in the driver's seat of a car with two bodies, a car riddled with and when he shows up with a change of clothing, change of shirt, powder residue on his hands, evidencing that he has discharged a firearm. And he lies. He lies about where the incident occurred. He lies about how it occurred. And he lies about not having a phone. I think it was Miss Bradley herself who said, everybody has a phone in his pocket, not Corwell Henry.
Everyone's afraid of going to the
Melly's own lawyer was revealing that it was Borland that was lying to the feds and that he was the one with powder residue on his hands. They even brought up a forensic scientist that covered the passings to go into further detail about Borland having the powder residue.
So the right hand of Cortland Henry contained 0 particles characteristic of powder residue and 2 component particles. And the left hand contained 1 particle characteristic of powder residue and 1 2-component particle. Okay.
And can you explain to us what that means?
Basically, overall, there was powder residue present on the hands.
As what you didn't know is that Borland didn't like this at all. This is why when Melly's mistrial was granted, a report shared, YW Borland tweets a mysterious message on the same day Melly's mistrial was declared. The tweet reads, "Mind games don't work on people like me," alongside a handshake emoji as if he's accepting a deal. Now this is where it gets very scary. If Borland is sitting alongside Melly in the trial, the feds can then also use Borland's interrogation on the night of the crime, where he was caught lying to police trying to cover up for his best friend Melly.
Okay, tell me what happened. Man, I was playing music, getting off the exit. I was already getting sleepy, almost home. You know what I'm saying? And like just out of nowhere, like I just heard, you know what I'm saying? So then I ducked down, you know what I'm saying, in the car. And I almost crashed.
Let me back you up a few minutes. Where were you coming from?
I was coming from the studio, from Fort Lauderdale.
Fort Lauderdale studio. Which way did you take?
I took I-75, 595 to
75. Then you took 75 south?
It's clear to officers that YW Borland's story isn't adding up to anything. Mind you, this is on the night of the crime. Borland is sitting trying to act confident about his story, trying to make it seem realistic so then they don't get caught up in a lie. However, this didn't work at all, where YW Borland would be caught in that lie.
Here's the hard part, where we're having a hard time to understand, is that we shut down that entire area, and we had officers shoulder to shoulder walking out. They didn't find as much as 1 shell casing. They didn't find 1 piece of glass. Nothing. Nothing to what you said adds up. And it's hard.
Bro, I'm telling you, bro, that's the class.
I mean, for whatever reason, your 2 friends, are these your good friends?
Yeah, that's what I'm saying. These are my, like,
these your 2, I'm assuming, close friends.
Yeah, yo.
And you're doing them an inservice by not telling us the truth.
I'm telling you the truth, son. What do you want?
How do you make shell casings disappear?
Motherfuckers pick them up.
I don't know. How can I tell you about a cell case?
This is where the interrogation would go south. YNW Borland begins getting angry as the officers aren't fully believing his story about the crime. And you can tell he's beginning to sweat because all he wants to do is get out of the interrogation room.
I told y'all the story, and that's it, bro. I don't even talk about it. Like, cause I told y'all. Like, I don't know. Like, I don't know.
Okay. Just so you know, all right, because you're saying, well, I don't want to talk anymore. There's going to be a lot more questions. And we're not trying to piss you off. The thing is, we don't know your friends.
Yeah.
So the reason we have to ask all these questions, because the more we know about your friends, your lifestyle, your friend's lifestyle, your friends, his friends, and the circumstances surrounding today, the more, easier it's going to be for us to try and solve this.
Commonly, when the criminal in the interrogation hits this point of the interview, refusing to talk and not even wanting to discuss further, it's then the officer's job to reset the playing field to try to gain the trust back. The goal is to continue asking questions, hoping either the criminal will mix up his story and share different details than what he originally said, or just accidentally says too much. As the officer would then reset the conversation, the police officer would want details of the in-the-moment actions made during the drive-by. How was he driving? Did he crash into anything or drop any items?
And I'm driving, ducking for my life, trying to make sure I don't get hit. And you telling me you telling me about I don't know. You know what I'm saying? I'm trying to make sure I don't get hit. I'm driving. I'm trying to make sure I don't get hit. You know what I'm saying? What I'm gonna be worried about it. You know what I'm saying?
I know it's not for you to worry about.
Shit crazy, bro.
But if you tell me it happened there's got to be some evidence there. There's going to be broken glass, just like there's broken glass over here from when you guys open the doors and stuff like that. Okay, there's going to be broken glass over there when the windows got out. There's going to be casings from the people at your car. Okay, there's going to be evidence over there. Okay, right now, there's nothing. I kind of think I know what happened, because I got information.
With time running out in their allowed interrogation time, the officer would then flat out ask, if you know who did this, would you tell me?
By just telling me the truth, even if it's something that I don't want to hear, but I respect the truth rather than BS, okay? And a simple question. If you knew who did this, okay, you may or may not know. If you knew who did this, would you tell me? It's either a yes or no question. Answer.
Why the fuck would he tell you?
Honestly.
Yeah, honestly. The truth. You wouldn't?
Because I wouldn't want to be a part of it. I wouldn't want to be.
Now, YNW Borland doesn't give a firm yes or no. He doesn't use his voice at all, which is very important. Instead, he is shaking his head no. This is because if YNW Melly did do the crime, Borland would obviously know that. So him saying no to the officer could have caused his voice to crack or come out in a different pitch than used in the rest of the interview. That would be due to him lying. This would then be an obvious indicator to police that he knows a lot more than what he's sharing. But it gets even worse from here. Did you know the judge created a deal with Melly's ex-girlfriend? Her name is Mariah Hamilton. She was hiding out of the United States since before Melly's original trial. She was supposed to testify against Melly, but she never showed up. She was then wanted by police for the last few years.
Mariah Hamilton is spending her first day at the Broward County Jail. She has no arrest record until now. U.S. Border Patrol agents arrested her at Miami International Airport Monday after she arrived on an international flight. Court records show Hamilton was ordered to testify in Demon's first trial in 2023.
As the judge made a deal with Mariah, saying if you agree to testify against Melly, you're free to go out of jail. She accepted it instantly, making it the worst news imaginable for YNW Melly. Once released, she wrote on Facebook, "And to my village, thank you to my village. I love you all so much. God's plan, not mine." Why it's so scary is because they found disturbing evidence in Mariah's iCloud account relating to YNW Melly forcing her to not testify in trial. This is known as witness tampering. This alone carries a life sentence in prison, regardless if Melly actually took out about Sack Chaser and Juvie.
The state filing 6 new charges against Demings and 2 others who were allegedly involved. The charges include tampering with a witness, directing the activities of a criminal, solicitation or conspiracy to commit tampering, and unlawful use of a two-way communication device. Now, a couple of those charges actually carry a life in prison sentence if there's a conviction.
The witness tampering case would also be separate from his existing case of Sack Chaser and Juvie's passing. Due to Melly already having a mistrial in the original, there is an actual chance Melly is found not guilty of Sack Chaser and Juvie passing away, but depending on what evidence is on Mariah's iCloud account, he could be found guilty of witness tampering and still go to prison for life. Due to him witness tampering, the jail phones have been cut off from YNW Melly. He hasn't been allowed to use one for several months. It even got so bad, Jamie King did an interview exposing the county jail for not allowing him to use a phone.
And that's what the judge was saying. Oh, what is saying that he's getting treated wrong? Bitch, we know he is.
The right to use a telephone. They have a right.
That judge is racist, nigga.
To be allowed to write letters to their loved ones, to receive their mail. They hold his mail. They don't give it to him.
But if the evidence is true that YNW Melly was using a jail phone to commit witness tampering, that's why they've cut him off from usage. The scariest part is they definitely have the evidence stored away. They wouldn't just keep him off of the jail phone if it was a hunch that he was committing this crime. This would then result in a major lawsuit that the jail wouldn't risk doing. However, the judge was still willing to release Melly from jail, inviting him to the courtroom to speak on the specifics.
Good morning, this is on State of Florida versus Jamel Demings. Present is Mr. Demings. Mr. Demings, can you hear?
Alright, that. So as you can see from that, man, this judge, he not listening to a motherfucking thing. YNW Melly saying, lawyer saying. I feel like he already got his mind made up. Like they done changed his other judge, the moldy motherfucker, to this square cob head ass. A lot of shit that they trying to do, man, is they saying, man, we spent all this money on it, all this attention. Ain't no damn way we finna try to let your ass go for the free ski. You know what I'm saying? So it's like, even if they gotta make up some shit. You know what I'm saying? Use some shit that's not really, they don't even have no proof, no real hard court evidence. They just going off of motherfucking like text or shit. You know what I'm saying? Like, crip. So it's like, fuck. Hey, like I said, bro, I know YNW can win because they got a mistrial. So it's still hope out here. And then you got faith, like, bro, I feel like he can beat this case, man. They just gotta stop putting themselves in the way of fucking their own self up with this bullshit. Which I feel like, man, they hold it down, this whole system of what they got going from the people. But they like keep on standing on 10. We out this bitch. Good, no side, big Quicc gang.
Hey, Dad, you know, dog, when we link up, dog, this shit be legendary. You know this instrumental, you the engineer on it, so Kodak everywhere.